The Foreign Intelligence Surveillance Act of 1978 is a United States federal law which prescribes procedures for the physical and electronic surveillance and collection of foreign intelligence information between foreign powers and agents of foreign powers. It has been repeatedly amended since the September 11 attacks. Subsequent amendments. The Act was amended in 2001 by the USA Patriot Act, primarily to include terrorism on behalf of groups that are not specifically backed by a foreign government. An overhaul of the bill, the Protect America Act of 2007, was signed into law on August 5, 2007. It expired on February 17, 2008. The FISA Amendments Act of 2008 passed by the United States Congress on July 9, 2008. History. The Foreign Intelligence Surveillance Act was introduced on May 18, 1977, by Senator Ted Kennedy and was signed into law by President Carter in 1978. The bill was co-sponsored by 9 senators: Birchbay, James O. Eastland, Jake Garn, Walter Huddleston, Daniel Inouye, Charles Mathias, John L. McClellan, Gaylord Nelson, and Strom Thurmond. The FISA resulted from extensive investigations by Senate committees into the legality of domestic intelligence activities. These investigations were led separately by Sam Ervin and Frank Church in 1978 as a response to President Richard Nixon's usage of federal resources to spy on political and activist groups. The act was created to provide judicial and congressional oversight of the government's covert surveillance activities of foreign entities and individuals in the United States, while maintaining the secrecy needed to protect national security. It allowed surveillance, without court order, within the United States for up to 1 year unless the surveillance will acquire the contents of any communication to which a United States person is a party. If a United States person is involved, judicial authorization was required within 72 hours after surveillance begins. Warrantless domestic wiretapping program. The act came into public prominence in December 2005 following publication by the New York Times of an article that described a program of warrantless domestic wiretapping ordered by the Bush administration and carried out by the National Security Agency since 2002. A subsequent Bloomberg article suggested that this may have already begun by June 2000. Scope and limits. For most purposes, including electronic surveillance and physical searches, foreign powers means a foreign government, any faction of foreign governments not substantially composed of U.S. persons, and any entity directed or controlled by a foreign government. Sections 1801. The definition also includes groups engaged in international terrorism and foreign political organizations. Sections 1801 and the sections of FISA authorizing electronic surveillance and physical searches without a court order specifically exclude their application to groups engaged in international terrorism. See Section 1802, and the statute includes limits on how it may be applied to U.S. persons. A U.S. person includes citizens, lawfully admitted permanent resident aliens, and corporations incorporated in the United States. The Code defines foreign intelligence information to mean information necessary to protect the United States against actual or potential grave attack, sabotage, or international terrorism. In sum, a significant purpose of the electronic surveillance must be to obtain intelligence in the United States on foreign powers or individuals connected to international terrorist groups. To use FISA, the government must show probable cause that the target of the surveillance is a foreign power or agent of a foreign power. Provisions. The subchapters of FISA provide for electronic surveillance. physical searches, pen registers and trap and amp trace devices for foreign intelligence purposes, access to certain business records for foreign intelligence purposes. Reporting requirement. The Act created a court which meets in secret and approves or denies requests for search warrants. Only the number of warrants applied for, issued and denied is reported. In 1980, it approved 322 warrants. This number has steadily grown to 2,224 warrants in 2006. In the period 1979 to 2006, a total of 22,990 applications for warrants were made to the court, of which 22,985 were approved, and only 5 were definitively rejected. Electronic surveillance. Generally, the statute permits electronic surveillance in 2 different scenarios. Without a court order, the President may authorize, through the Attorney General, electronic surveillance without a court order for the period of 1 year, provided it is only for foreign intelligence information, targeting foreign powers as defined by 50 U.S.C. Section 1801, in certain conditions, and there is no substantial likelihood that the surveillance will acquire the contents of any communication to which a United States person is a party. The Attorney General is required to make a certification of these conditions under seal to the Foreign Intelligence Surveillance Court, and report on their compliance to the House Permanent Select Committee on Intelligence and the Senate Select Committee on Intelligence. Since 50 U.S.C. Section 1802 of this Act specifically limits warrantless surveillance to foreign powers as defined by 50 U.S.C. Section 1801, and omits the definitions contained in 50 U.S.C. Section 1801, the Act does not authorize the use of warrantless surveillance on groups engaged in international terrorism or activities in preparation therefor. Foreign-based political organizations, not substantially composed of United States persons, or entities that are directed and controlled by a foreign government or governments. Under the FISA Act, anyone who engages in electronic surveillance except as authorized by statute is subject to both criminal penalties and civil liabilities. Under 50 U.S.C. Section 1811, the President may also authorize warrantless surveillance at the beginning of a war. Specifically, he may authorize such surveillance for a period not to exceed 15 calendar days following a declaration of war by the Congress, with a court order. Alternatively, the government may seek a court order permitting the surveillance using the FISA court. Approval of a FISA application requires the court find probable cause that the target of the surveillance be a foreign power or an agent of a foreign power, and that the places at which surveillance is requested is used or will be used by that foreign power or its agent. In addition, the court must find that the proposed surveillance meets certain minimization requirements for information pertaining to U.S. persons. Depending on the type of surveillance, approved orders or extensions of orders may be active for 90 days, 120 days, or a year. Physical searches. In addition to electronic surveillance, FISA permits the physical search of the premises, information, material, or property used exclusively by a foreign power. The requirements and procedures are nearly identical to those for electronic surveillance. FISA Court. The Act created the Foreign Intelligence Surveillance Court and enabled it to oversee requests for surveillance warrants by federal law enforcement and intelligence agencies against suspected foreign intelligence agents inside the U.S. The court is located within the E. Barrett Prettyman United States Courthouse in Washington, D.C. The court is staffed by 11 judges appointed by the Chief Justice of the United States to serve 7-year terms. Proceedings before the FISA court are ex parte and non-adversarial. The court hears evidence presented solely by the Department of Justice. There is no provision for a release of information regarding such hearings, or for the record of information actually collected. Denials of FISA applications by the FISA may be appealed to the Foreign Intelligence Surveillance Court of Review. The Court of Review is a three-judge panel. Since its creation, the court has come into session twice, in 2002 and 2008. Remedies for violations. Both the subchapters covering physical searches and electronic surveillance provide for criminal and civil liability for violations of FISA. Criminal sanctions follows violations of electronic surveillance by intentionally engaging in electronic surveillance under the color of law or through disclosing information known to have been obtained through unauthorized surveillance. The penalties for either act are fines up to $10,000, up to 5 years in jail, or both. In addition, the statute creates a cause of action for private individuals whose communications were unlawfully monitored. The statute permits actual damages of not less than $1,000 or $100 per day. In addition, that statute authorizes punitive damages and an award of attorney's fees. Similar liability is found under the subchapter pertaining to physical searches. In both cases, the statute creates an affirmative defense for law enforcement personnel acting within their official duties and pursuant to a valid court order. Presumably, such a defense is not available to those operating exclusively under presidential authorization. Lone Wolfe Amendment. In 2004, FISA was amended to include a lone wolf provision. 50 U.S.C. Section 1801. A lone wolf is a non-U.S. person who engages in or prepares for international terrorism. The provision amended the definition of foreign power to permit the FISA courts to issue surveillance and physical search orders without having to find a connection between the lone wolf and a foreign government or terrorist group. However, if the court authorizes such a surveillance or physical search using this new definition of agent of a foreign power, the FISA judge has to find in pertinent part that, based upon the information provided by the applicant for the order, the target had engaged in or was engaging in international terrorism or activities in preparation therefor. Constitutionality. Before FISA, in 1967, the Supreme Court of the United States held that the requirements of the Fourth Amendment applied equally to electronic surveillance and to physical searches. Katz v. United States, 389 U.S. 347. The court did not address whether such requirements apply to issues of national security. Shortly after, in 1972, the court took up the issue again in United States v. United States District Court, Clarendon, where the court held that court approval was required in order for the domestic surveillance to satisfy the Fourth Amendment. 407 U.S. 297. Justice Powell wrote that the decision did not address this issue that may be involved with respect to activities of foreign powers or their agents. In the time immediately preceding FISA, a number of courts squarely addressed the issue of warrantless wiretaps. In both United States v. Brown 484 F2D 418 and United States v. Butenko 494 F2D 593, the courts upheld warrantless wiretaps. In Brown, a U.S. citizen's conversation was captured by a wiretap authorized by the Attorney General for foreign intelligence purposes. In Butenko, the court held a wiretap valid if the primary purpose was for gathering foreign intelligence information. A plurality opinion in Svibon v. Mitchell, 516 F. 2D 594, held that a warrant was required for the domestic surveillance of a domestic organization. In this case, the court found that the domestic organization was not a foreign power, their agent, and absent exigent circumstances, all warrantless electronic surveillance is unreasonable and therefore unconstitutional. Post-FISA, there have been very few cases involving the constitutionality of FISA. Two lower court decisions found FISA constitutional. In United States v. Duggan, the defendants were members of the Irish Republican Army. 743 F2D 59. They were convicted for various violations regarding the shipment of explosives and firearms. The court held that there were compelling considerations of national security in the distinction between the treatment of U.S. citizens and non-resident aliens. In the United States v. Nicholson, the defendant moved to suppress all evidence gathered under a FISA order. 955 F. Sup. 588. The court affirmed the denial of the motion, though the court flatly rejected claims that FISA violated due process clause of the Fifth Amendment, equal protection, separation of powers, nor the right to counsel provided by the Sixth Amendment. However, in a third case, the Special Review Court for FISA, the equivalent of a Circuit Court of Appeals, opined differently. Should FISA limit the President's inherent authority for warrantless searches in the foreign intelligence area? In resealed case 310 F. 3D 717, 742, the special court stated all the other courts to have decided the issue held that the President did have inherent authority to conduct warrantless searches to obtain foreign intelligence information. We take for granted that the President does have that authority and, assuming that is so, FISA could not encroach on the President's constitutional power. Criticism. K.A. Type A of the World Policy Institute, James J. Carafano of the Heritage Foundation, and Philip Bobbitt of Columbia Law School, among others, have argued that FISA may need to be amended to include, among other things, procedures for programmatic approvals, as it may no longer be adequate to address certain foreign intelligence needs and technology developments, including the transition from circuit-based communications to packet-based communications, the globalization of telecommunication infrastructure, and the development of automated monitoring techniques, including data mining and traffic analysis. John R. Schmidt, Associate Attorney General in the Justice Department under President Bill Clinton, expressed a need for programmatic approval of technology-enabled surveillance programs. He recalled early arguments made by then Attorney General Edward Levi to the Church Committee that foreign intelligence surveillance legislation should include provisions for programmatically authorizing surveillance programs because of the particular needs of foreign intelligence where virtually continuous surveillance, which by its nature does not have specifically predetermined targets, may be required. In these situations, the efficiency of a warrant requirement would be minimal. In a 2006 opinion, Judge Richard Posner wrote that FISA retains value as a framework for monitoring the communications of known terrorists, but it is hopeless as a framework for detecting terrorists. Requires that surveillance be conducted pursuant to warrants based on probable cause to believe that the target of surveillance is a terrorist, when the desperate need is to find out who is a terrorist.